call the meeting to order. May we have roll call, please?
Ms. Moore?
Here.
Mr. Gillis?
Here.
Mr. Pollack?
Here.
Ms. Hughes is absent. Mr. Sheridan?
Here.
Mr. Wright?
Here.
Mr. Lopez is absent.
Okay, thank you. If everyone would check their cell phones and make sure that they're turned off at this time, including the board members. Okay, the first item on the agenda is approval of the minutes from the June 11th, 2013 meeting.
Madam Chair,
Mr. Sheridan?
motion to approve minutes from Tuesday, June 11, 2013.
Thank you. Do we have a second?
Second.
Thank you. Is there any discussion? Okay, seeing none, we'll call the vote. All those in favor say aye.
Aye.
Opposed? Motion carries. Next item on the agenda is public comment. Is there anyone here wishing to speak to the board on any item that's not on the agenda tonight? Seeing none, we'll close public comment. There are no public meeting items. The next item is public hearings. The McClellan Office Building extension of the Site Development Order 365-06. Is the applicant present? You come up to the podium, please. You would state your name and address for the record, and this is your time to tell the board about your request and why you think we should grant it.
Okay, my name's Joe McClellan at 654 Yorkshire Drive, Oviedo, Florida. The property that we're talking about is 396 West Broadway in Oviedo. I've owned it, or my parents have owned it, since 1962. Okay, planned on putting an office building in there, and right after I worked it through the city of Oviedo, got plans, and it was approved, DOT decided they were going to widen Broadway. And at that time, they were going to take a certain section of my property. And then the next meeting, those plans changed. So it was kind of unknowing what the DOT wanted to do with that right-of-way through there on my piece of property. And then as soon as they settled, or at that time settled what they were going to do, the economy went south, and I decided to hold off until the economy turned back around to do anything, and also until DOT decides what they're going to do, because it affects what I was going to do. And any questions?
Is that all of your presentation?
I still plan on doing it, but it's just, I'm kind of up in the air because DOT or the city ran out of money when they were going to do the widening from, I think it was from Pine Street on east. And that kind of put a kink in my plans. That's it.
Okay.
All right.
Are there any questions of the applicant? Thank you.
All right.
May we hear from staff?
Thank you, Madam Chair. This is a request for the PZA to approve an extension of Site Development Order Number 365-06 and the associated site development plan for 4,780 square foot office use on approximately 0.88 acres. The subject property is located on the south side of West Broadway Street, approximately 700 feet west of the intersection of Lake Jessup and Broadway Street. The proposed development will include approximately 4,780 square feet of office use. Access is provided via West Broadway. This item was approved by PZA on August 22nd, 2006. On February 2nd, the applicant sent a letter to the city requesting that the site development order be extended. Due to the economy, the applicant has been unable to begin construction. Staff reviewed the subject site development order extension request per the requirements of the Land Development Code and Comprehensive Plan and recommends approval. The Land Development Code allows the approving authority to extend the site development order for a period of 12 months. The developer can apply for another extension if needed prior to the expiration of the proposed extension. It is recommended that the PZA approve the 12-month extension of Site Development Order Number 365-06 and the associated site development plan for the McClellan Office Building. This concludes staff's presentation, and we're available for questions.
Thank you. Are there questions of staff?
Madam Chair.
Yes.
I have a question. How, what is the maximum, I know it's 12 months, but the maximum extensions, how many extensions are allowed?
There's no limit on the number of extensions.
There is no limit?
No.
Okay.
Are there any other questions of staff? Okay, we'll open it up for public hearing. Is there anyone here wishing to speak on this item? Seeing none, we'll close public hearing. What's the board's pleasure?
Madam Chair, I'd like to recommend approval of site development order number 365-06.
Thank you, Mr. Pollack. Do we have a second?
Second.
Mr. Gillis? Is there any discussion? Okay, we'll call the vote. All those in favor say aye.
Aye.
Opposed? Motion carries. Good luck.
Sure.
Okay, the next item on the agenda is the Taylor Landing Commercial Center Site Development Order 398-08. Is the applicant present? Can you come to the podium, please? State your name and address for the record. Tell us why, tell us about your request and why we should grant it.
Thank you, Madam Chairman. My name is George Veely. I reside at 301 Carolyn Drive here in Oviedo. I purchased this property back in 2008, and we spent probably 18 months or so going through the design and review and approvals and getting all the permits, expended quite a bit of time and energy and money doing so. The project consists of two buildings, a retail building and an office building. And about that time, I don't have to tell you, 2008, things kind of slowed down dramatically. We hoped that the recession would last maybe a year or two, but it seems to be dragging out probably a lot more than anybody's thought. The project was designed to meet all the codes. It's a good project. I think it's a very viable project. We have several parties that are interested in it right now, so we're hoping that something's going to happen in the near future. It's a perfectly good development plan. We put a lot of work into it, and we would request that you approve a one-year extension. If you have any questions, I'd be happy to answer those. Thank you.
Thank you. Are there any questions of the applicant? May we hear from staff?
Thank you, Madam Chair. This is a request for the PZA to approve an extension of Site Development Order Number 398-08 and the associated site development plan for approximately 15,210 square feet of commercial use on approximately 1.60 acres. The subject property is located within the Wheelers Corner PUD. The approved commercial development will include a total of 15,210 square feet of commercial office uses. Access from the west is provided via driveway to Swanson Drive, a private street, and to the east via a driveway that connects via a cross-access easement with Lockwood Boulevard. The site development order and site development plan was approved by PZA on July 8, 2008. On May 2nd, the applicant sent a letter to the city requesting that the site development order and associated site development plan be extended for 2 years. Due to the economy, the applicant has been able to begin construction. The applicant is marketing the property and hopes to develop as soon as the market conditions permit. Staff reviewed the subject site development order extension per the requirements of Land Development Code and the Comprehensive Plan. The Land Development Code allows the approving authority to extend the site development order for a period of 12 months. The developer can apply for another extension if needed prior to the expiration of the proposed extension. Staff recommends approval of the 12-month extension. It is recommended that the PZA approve the 12-month extension of site development order number 398-08 and the associated site development plan for Taylor Landing. This concludes staff's presentation, and I'm available for questions.
Thank you. Are there any questions of staff? Okay. Or the next thing to do is public comment. We'll open it up for public hearing. Is there anyone wishing to speak to the board at this time? Seeing none, we'll close public comment. What's the board's pleasure?
Madam Chair,
Yes.
I'd like to make a motion that we approve the extension, 12-month extension for site development order number 398-08.
Thank you, Mr. Sheridan. Do we have a second?
Second.
Is it Mr. Gillis? Okay, thank you. Is there any discussion?
No, ma'am.
Okay, we'll call the vote. All those in favor say aye.
Aye.
Opposed? Motion carries. Good luck. Okay, the next item on our agenda is discussion items. Mr. Groot, I think you're up.
Good evening. I hope I won't take too long tonight, and I just want, I know, y'all are all heard most everything I'm going to say before, but it's good to go through some refresher, I guess, from time to time. And so, I apologize in advance for being somewhat repetitive of things you may have heard, but maybe you'll learn something new or think of something new. First, what I'm going to do is go over the grand scheme of things, and then we'll go into some specific handouts, okay? So let's just go back to the grand scheme of things. And, the land use process in Florida starts with the comprehensive plan. Comprehensive plan is the land use constitution of a jurisdiction, okay? All decisions involving a comprehensive plan, whether it's a half-acre site or a 500-acre site, are legislative. There was court battles that went all the way to the Florida Supreme Court about whether a small-scale amendment was quasi-judicial or legislative. It's legislative. It's established. So anything involving a comprehensive plan amendment, you can talk to any citizen you want. You should talk to citizens. You should listen to them. They can lobby you. You can not talk to each other, but you can talk to all, citizens. You can talk to staff, and you don't have to tell anybody at a public hearing who you talk to about the decision you're going to make on a comprehensive plan amendment. Okay? It's purely legislative. Okay. Zoning decisions, zonings are like the statutes. If the comp plan is the Constitution, then the zoning's the statutes. Okay? Now, a zoning on a particular piece of property is a quasi-judicial act because you're determining, based upon facts, what zoning classification to assign that piece of property. Now, there's an exception to that. Back when Seminole County rezoned the entire third of the county, the east area, that was a legislative act. So a large zoning act can be legislative. Okay, but that's just an exception to the rule. Your typical zoning decision is a quasi-judicial act. Now, when you change the land development code to regulate colors, uses, setbacks, or you alter the procedures in the code, those are all legislative acts because you're not applying facts to a person's property. You're not applying a rule of law to a particular piece of property. So those are all legislative. So whenever I say legislative, that means talk to everybody. You're legislators, and we have a constitutional right in Florida to instruct our representatives. Is the way it's stated in our Constitution, that we have the right to instruct our representatives. So when it comes to comprehensive plan and other legislative decisions, your citizens who you serve can instruct you. Okay, they can lobby you. Then there's other decisions that are sub-zoning, sub-assigning a particular zoning classification to a particular piece of property. We call them, one thing, for example, deviations. What most jurisdictions call those variances. Those are quasi-judicial. Special exceptions or conditional use. Those are all quasi-judicial. So You have to disclose if you're outside contacts and all that. You're judges on those types of decisions. Okay? Now, what happens when a decision of the, well, you make a decision or a recommendation that goes to the city council, and the city council makes a final decision. What happens if that's challenged? What do courts look for? Well, the first layer of court review looks for three things. They look to see if procedural due process was afforded the parties. Okay. And one of the handouts I'm going to hand out was the proceeding fair? Did one side get to talk and the other one not? Did everybody get the same amount of time, more or less? Was evidence allowed? So procedural due process. The second thing that a court will look for is what's called, did the local government comport with the essential requirements of law? What that means is that did the local government apply the correct law? Now, it's really funny when you hear what I'm going to say next, because the question is, was the correct law applied? Not was it applied correctly. It's just, did you apply the Land Development Code? Yes, there you go. So it's procedural due process, you applied the Land Development Code. And the third thing that the first layer of court review will look at is, was there substantial competent evidence of record to support the decision? Okay? You all know, because of the criminal trials you've been forced to watch on TV, that what's the criminal standard of proof? Beyond a reasonable doubt. We all know that. Okay. And the civil court system is preponderance of evidence. 50.1 to 49.9. 50.1 wins. In land use decisions, it's just, was there competent evidence to support the decision? Any evidence. Doesn't have to be 50.1. Any evidence. So when the decisions of local governments go to courts, they go pretty much presuming that everything's going to be sustained. There's a lot of deference given. And if an appeal goes to the next layer of courts, like the District Court of Appeal, that substantial competent evidence standard, that goes away. So the next layer of appeal is just, was it procedural due process afforded? Were the essential requirements of law honored? Was the correct law applied? And the evidence isn't looked at all. Okay. So that's the worldview of land use decision making. That's where you fit in to the worldview. Okay. Is there any questions about that? Now this little handout sort of goes over that a little more specifically. Always got to take care of it first. Anything else I can do? We already got that. Okay.
Evidence that they would need, like if they wanted to recommend denial of a comprehensive plan amendment.
I remember I gave you that a long time ago.
It's time to update your media.
Okay. I'll give you the statute. This is section 166.033 statute. It relates to cities. The counties were not overlooked. The section in chapter 125 is really virtually identical to this. Okay? And what this statute says is the operative part. When any municipality denies an application for a development permit, a development permit, if you read the definition, it refers to everything. Zoning, everything that relates to land use. The municipality shall give written notice to the applicant. Okay. The notice must include a citation to the applicable portions of the ordinance, rule, statute, or other legal authority for the denial of the permit. Okay. I'm not going to read beyond that. But a development order, well, a decision on an application that results in a denial, you got to say why. Okay, so to answer Deborah's question, you say why from a code perspective, then what facts relate to those codes? Okay? What do you have to look at, Deborah? The facts that pertain to the issues that the code presents. Okay? And we'll have an example. This is the City of Sanford denial of development order relating to historic preservation. Very important to spell out the facts, because who's determining the facts? Forever. You are a city councilor. This is the time to spell out the facts, because the courts, they're not going to hear evidence. They're going to hear a record. They're going to, just like at the end of that handout that you already had, talks about the record. That's what a court's going to look at, the record. Deborah's not going to testify. None of y'all are going to testify. City council's not going to testify. It's all based upon the record. What was said, what evidence was presented, what conclusions were made. Well, this tells the story. The development, and that's, I like to go to when I argue in front of a court, I like to say, Judge, you don't have to read that 600-page or 500-page record. Here's the facts that were found. This is what the decision-making body found to be important. Now, if that's not enough, that's a problem. But if it's enough, it's not a problem. So in the context of this Historic Preservation Board decision, if you look starting like around page 3, it lists all these different code provisions. That S-32, that's Schedule S of their code, and I think it's page 32. And all these facts are found to be basis for denial. Okay? So if a 15-foot setback is required and there was no deviation granted to the setback requirements and there wasn't a 15-foot setback, that's a fact to be found. That's a reason to deny. Now I think what Deborah really is focusing on, however, is the more subjective type of decisions, such as compatibility. Okay? Right?
That's correct.
I've got approval development order here, too. I'll have that. Okay, what evidence is there? Is there a definition of compatibility in the Land Development Code?
No, sir.
Okay. And is there one in the comp plan?
We have criteria that would demonstrate compatibility
And that's,
in the comprehensive.
those are the standards then. Does it adversely impact the abutting property?
Is it similar to properties surrounding?
Well, is it similar, or is there a plan of tiered step-down development? Is there a policy in the comp plan about stepping down development? Industrial, commercial, high-density residential, medium-density classic, and low-density residential. Is there Does it step down, or does it go industrial, low-density residential? Well, those are typically not compatible, right? Now, who's presenting the evidence? There you go. A staff report alone is evidence enough. The courts have said that. So, if there's a and I've been the victim of this from a property owner's side. If there's, it's a hard thing to do to overcome a staff report, because now I've got to bring, people. What I say at a hearing as an attorney is not evidence. There's several cases that say that very thing, because attorneys get up and say, well, this is not compatible, and the road's this way, and and the lake's over there. Well, all that's argument from an attorney. It's not evidence. So I have to bring planners, architects if need be, God forbid, traffic engineers, other types of consultants, and the like. And to rebut that, and that's just to rebut the staff report. Okay? But the decisions have to be made on evidence, just like that denial development order was. Okay.
I have a quick question. Just looking at the statute the way it's read, since a lot of times we're a recommending board, we're not making the final decision. So in a sense where we're making a recommendation for either approval or denial to the city council for final disposition, since we're only recommending denial, do we still have to provide reasoning if we're...
Sure. And here's the classic example. What sport do you like? Yeah. Football. Okay. And I'm trying to, and I want a guy to play on your team. He's a great quarterback. Got any questions?
Yeah, I'm sure there'll be a lot of questions about that.
Well, yeah, so there you go. Well, how far can he throw? Can he throw the down and out? Does he have touch? Is he fast? Can he run? Is he a drop back, or is he, or can he roll out?
Again, I'm looking at it
but that's
really from the way it's worded.
But that's the point. Is that if you say recommend denial, that gives the city council no help whatsoever. You say recommend approval, that gives the city council no help whatsoever. If you say we recommend denial because it's inconsistent with comp plan policy, whatever, and because of the lack of compatibility, as evidenced by the fact that it's next to Forest Lake subdivision or whatever, that gives them something to go on, and that's will probably go into your staff report too, that the PZA found that, as opposed to the PZA recommended denial. And here's what happens too. Maybe I've said this to y'all before, but I've seen some horrible situations, not in this city, but some horrible situations in some other cities where there's a recommend of denial, say, and the city council says to the staff, why did they do that? And then staff gives an answer, and there's some board members either in the audience or hear what staff said, and guess what happens? That wasn't why. Why didn't you said this? Why didn't you say that? Or you said that, you should have said this. Or you didn't mention what Commissioner so-and-so said. Well, we didn't think that was the consensus. Well, it was. How do you know? So if you put in your motion, I moved to deny on the basis of X, Y, Z. Everybody agrees on that, or somebody says, how about A too? Well, okay, I agree. Let's put A in the motion too. Then that gives a basis for your recommendation. And that's valuable. That's valuable. I remember there was a council member in Palm Coast. He was a new person. He really turned into a great council member. There's parks named after him after he died and everything. And one time he wanted to talk to me after a meeting. And he said, I'm really upset, staff. What did they do this time? This time. Well, that's the politically correct answer. Because you don't say, And he said, you were at the last meeting, weren't you? I said, yes, sir. He said, well, I said this, and I said that, and I said this, and I said that. And then the motion was made to approve it. None of those things I said got put into the approval. That's exactly right. You talked a lot. You probably talked more than anybody. But you didn't make a motion, and you didn't ask for your stuff to be put into the motion. But you talked, you know, and in other words, you made some great points. People may have agreed with you, but they didn't get incorporated into the motion. And if you want your stuff to be put into the motion, you got to ask it to be put in the motion. So, you know, does that help?
No, again, and that's, we pretty much do that anyway. But
Yeah.
just the way I was reading it, though, I was like, you know, is there a distinction between when we are the final approval board where, you know, we have to get...
There is no
permission,
distinction.
but versus recommending, you know, again, whether or not it really, at that point, would have to be locked in. But it's in your mind, what you're telling me is that it's more favorable to the council.
Absolutely, absolutely. I mean, they appoint y'all for, you know, reason, and it's important what you say.
I mean, 99% of our, well, again, I'm just making that assumption, my number, but of our approvals don't include any type of why. I mean, it's just we recommend approval. Ordinance,
Which is why
ordinance such and such done. You know, I mean, there's a few times, you know, that we'll add.
Well, you know, when you make a motion to recommend approval of an ordinance, the most important finding in the whole land use process is incorporated into that motion, and that you're saying that that's consistent with the comp plan. Whenever you recommend approval of an, the only reason ordinances come to you is because the statute says they have to, for you to find that they're consistent with the comp plan. So when you recommend approval, you're finding that every goal, every objective, every policy of that comp plan is compatible with what's in that ordinance. So it's inherent in your motion.
Thank you.
Mm-hmm. The other thing I think that was asked about, that I discussed, this is an approval of all. Mirror image of that is approval. And, you know, by the way, one of the easiest ways to make a motion to deny is that it's inconsistent with the comp plan. I believe the denial is basically the comp plan. You can't argue with that.
You had to name the inconsistencies?
Well, I was just going to tell you the story. Because that one member of a board I was sitting on did that one time. And he was a very respected member, highly intelligent person. And, but they didn't let him get away with that. They knew he was against a development, and they knew that he was going to make the motion, and so he made the motion. And he had heard what I'd said, that, you know, one way to kill an item is to say it's inconsistent with the comp plan. And the chairman said, okay, what goal, objective, or policy? He said, well, I'm just saying it's general. He said, I won't accept the motion that way. So what goal? 40 minutes later, because they recessed while he researched the comp plan and came up with what he wanted to put in his motion as inconsistent goals, objectives, and policies. He made the motion with the several stated provisions, and but it took 40 minutes. They gave him 40 minutes. But you should, you know, if you're going to make that motion, it's best to have read the comp plan beforehand. You know, site visits, real quickly. Site visits on legislative matters, once again, fine. You know, no issue whatsoever. If you make a site visit on a quasi-judicial matter, you ought to say, you ought to disclose that you did. I went to the site and on such and such a day, and I looked at it. Now you're home free, you know. And by the way, you're home free as long as you can say the following thing and mean it, and it's true. Jimmy Jones talked to me, and he was absolutely against it. Sally Green talked to me, and she was absolutely for this. I went to the site, and I looked at the site myself. But I'm making, here's the words, the magic words, but I'm making my decision on what I hear tonight at this hearing. You've now disclosed everything that you've done. I don't mean that done in the negative sense either. But you've also said, convince me, everybody. Convince me, developer. Convince me, staff. I'm here to be convinced. So that will save the day if there's any ex parte contacts, or if you visited the site, you know. But you have to be able to say that honestly, and you all are the judges. You've heard me say this before, most of you, but you are the judges. So you can't become, no matter how, it's tempting. I know it's tempting. You all know J.R. Ball. He's a very good friend of mine, and one day, was he chair? He was chair.
He's not chair.
No, he was chair. And he came, there was a drainage issue or something on a particular development, and he's a drainage engineer type, and he came loaded for bear because he had studied it and all that, and he had run calculations, and I had to be the one to say, you can't do this. You have to either throw all that away, listen to what's out here. But they might be wrong. That's exactly right. They might be, but that's the evidence. It's, so. Well, that's sort of a rundown. The reason I gave you the denial development order and the approval development order is because 163.033 requires the denial. I think it assumes that you're going to have approval development orders too. Actually, that's where what the valuable document, that's what you take to the bank and say, look what I have, loan me money. That's why they're so important, and it's so important for them to say all the right things. Questions?
I have one.
Yes, ma'am.
If we have a situation where the public's very interested in it, we have a lot of folks show up about some project perhaps that's going on near their neighborhood, and they're all against it because they think it's incompatible with their neighborhood, but yet staff is telling us it is compatible according to the comp plan. Can we choose the public over our expert staff's report?
If their testimony is actually evidence. Okay, zoning decisions are not plebiscites. That's what one of the courts said. Okay, so if you raise your hand and say, if you ask, everybody raise your hand who thinks it's compatible. Everybody raise your hand who thinks it's not compatible. That's not evidence. That's a poll. Okay, but if a citizen can get up in front of you and say, having a Chili's in my backyard, no matter what the zoning of the property is incompatible and is inconsistent. Somebody can make a comp plan consistency argument in front of you. Zoning can be in place, and they could come in and say it's wrong. It's inconsistent with the comp plan. Now, they're going to have to give you goals, objectives, and policies to tell you why it's wrong. But they can say it's inconsistent with the plan, and it's incompatible because my single-family use will be adversely impacted by that Chili's. That's a compatibility argument. Deborah can't say anything more than that, except that she can say the zoning's okay, the setbacks are okay, the landscaping plan's okay. But when it comes to compatibility, she can say it's an allowable use under the comp plan. It's assigned that zoning classification, so a restaurant could go there. But if there's a compatibility standard, that's that's evidentiary. Okay? And you know what Seminole County did at one time, don't you? They got tired of, the county commission got tired of residential subdivisions coming in and folks opposing them even though they were at the same density as their subdivision, or the density was basically consistent with the area. So what Seminole County did, and it's still in the code, is they did it mathematically. Okay, they did it mathematically, and you go a certain area around the site that's proposed for a subdivision. You calculate the densities of all these subdivisions around. You do a mathematical formula, figure out what the average density is, and that's what is appropriate for this new site. Okay, so because they got tired of having the argument, so they wanted a very objective standard. So you can get that objective, but you also tie yourself in a box. And I had a client who proposed one of development that was consistent with that mathematical formula, and they denied it. So we had to take them to court and win. So, but they had no choice except to approve it. But they denied it, so they had no choice but losing. So yeah, as long as it's evidentiary, But if a citizen comes up and says the traffic's horrible, and the developer has a traffic engineer that says each level of service, and everything's fine, or if a citizen gets up and says the wetlands will be forever destroyed and this violates every code in the world, and the developer has an engineer who says meets St. John's requirements. One was opinion, the other was evidence. Okay, and so you can hear 100 of the opinions, and you know what they are? Opinions, but not evidence. And that's why I tell citizens get involved in comp planning, because once the land uses are set, it's all downhill from there. It's all entitlements from that point on. It's not decisions about how you want your community texture or how you want, Those are where the big compatibility issues are at the comp plan. Does that help?
It does.
Okay. What else can I do to let you guys get a movie? I want to go to the movie too. Can I come?
Lonnie, can you speak to, like our zoning districts, we have a permissible uses table. And in certain districts, let's say retail is allowed. And let's say that they may have to do a preliminary subdivision plan, which will come here because they want to divide it. But we know a particular use is going to go there. Can they deny a development permit based on the type of use that we know is going to go there?
And it will be a permitted use?
It's a permitted use. Like, let's say it's retail, and I don't want to say any names, but...
No. I got lectured when I first got to the Seminole County Attorney's Office in 1985 out of the JAG Court. I got handed a case. Does anybody remember Deer Run? Mm-hmm. Okay. Well, there was this undeveloped area in Deer Run, okay, that stayed undeveloped while the houses built all over it and filled up Deer Run. And there was this site, and guess what? Every realtor who sold a home, well, I shouldn't say that, but guess what? A lot of the people in the audience said their realtors told them when they sold them their homes, that cow pasture would always stay that way. Okay, that cow pasture was zoned commercial. So I think it was Winn-Dixie. Winn-Dixie came in and for a site plan approval. That's an entitlement. You know, if I have my sealed plans and they meet the setbacks and everything's right, the parking's right, and the landscaping's right, you have no choice. You have to approve it. The county commission denied it. Okay, and and I went to argue in front of Judge Davis at the time, and Judge Davis wouldn't let me say anything. But you need to go back and tell the county commission that that was an entitlement. I've read your briefs. There's nothing you can argue. I'm on the verge of sanctioning the county, but you go tell them that that was an entitlement, and they know better than that. And so that was the end of that story. But no, when you get to the point where the comp plan's in place, the zoning's in place, and it's a plan is submitted, whether it's a preliminary subdivision or a plat of a subdivision or a site plan or whatever you want to call it, and it complies with code, it's an entitlement.
What if, taking that example, in lieu of being a permitted use, it requires a special exception use approval. So it's allowable, but under a caveat that it has to have a special exception.
Okay, and there's criteria for special exceptions. And so here's a deviation, which is also called a variance in some jurisdictions, is grace. Okay, and it's an act of grace. And the applicant has to prove every single element to get a variance. And it's basically impossible to do, by the way. Okay? You know, they did a nationwide study, and it's like 90% of the variances that were granted nationwide didn't meet the standards. But anyway. A special exception is not an act of grace. It's actually a use. It's just a conditional use. Some places call special exceptions conditional uses. So if an applicant comes in and shows that it's an allowable conditional use, that they complied with the procedures, in other words, they paid their application fee, they filed the right application form and all that, and if they can demonstrate that there's no adverse effect from their use, then the burden shifts to either the staff, if they're against it, or the public, if they want to oppose it, to prove that adverse impact. Okay, so that's what you're fighting about. You know, and if it is it an adverse impact that could be corrected or minimized by more conditions? You know, so that's why you can add conditions and conditions and conditions to special exceptions. But it's really an entitlement if you can prove those things.
I think that's where I was thinking, is that a lot of times when they provide the backup for those to show that it does meet those conditions, sometimes there's a little bit of interpretation in there. You know, it's not necessarily fact-based. It's, you know, it's an assumption that was made that it meets that criteria.
Oh, yeah. I mean, for example, let's see, a horse stable. Seminole County used to have a lot of horse stables that were special exceptions. And the issue became, you know, hours of use, you know, light, you know, and things that weren't code-based, but became that if you do these things, then it will be acceptable. But if you don't do these things, it would be otherwise unacceptable. And that's where the big debate got it, you know, get going, and where the negotiations during breaks would occur with the district commissioner going out to the audience and stuff like that. So. Anything else, Deborah? You had something? Okay. Anything else I can do for you? Okay.
Thank you, Lonnie. Okay, we have no other discussion items listed. Does anyone have anything? While we're all here and we're in this session with Lonnie tonight, I wanted to talk to the board about a meeting that Deborah and I had a few weeks ago. We talked about some of the things about how our meetings proceed and things that we can do better as board members and things that the staff can do better to prepare us for the board meetings. And one of the requests that staff had is that for all of the board members to contact staff prior to each meeting and ask any questions that you have about the items. You may not have any questions. You may think you read it, you understand it, you got all the information you need for it, but it's still a good idea to call staff and say, just that, I read through this, is there anything else that I need to know? Did I miss anything? Just so that you've got that chance to talk to staff prior to the meeting. So if you do have questions about it, staff can research and bring that information to the meeting with them. We had an incident, I guess a couple of months ago now, where we did have a lot of questions one night, and staff didn't have a chance ahead of time to have any idea what our questions were, and they weren't prepared to answer any of them. And so if we have questions and we let them know ahead of time, then that gives them the opportunity to be able to provide us that information at the meeting. A few months ago when that happened, we ended up continuing the item that was before us until we could get more information. And if we do it ahead of time, then the applicants can move through the process rather than having us slow them down simply because either we or staff weren't prepared like we should have been for the meeting. One of the things that we talked about is there's lots of times we have applicants here who can't answer our questions. We ask them questions about their project, and they don't know this or they don't know that. And so many times we end up going ahead and approving their project when we didn't get our questions answered. And my attitude is at that point, if the person asking for some project to be approved and they can't answer our questions, that we do continue it until they can answer them. You know, maybe they need to go back and talk to their engineers or whoever it is that they need to speak with, or maybe they just need to do more research on their project themselves. That's something I think that we as the board ought to discuss and not really set a policy, but feel free to be able to say, we don't have the information we need, and someone move for a continuance. What do other board members think about that? Mr. Sheridan?
Yeah, I'm thinking how I want to phrase or what I'm trying to say. I hear what you're saying, and to an extent I agree. Having said that, if that was the case, then staff shouldn't be presenting the item because they're either coming to us with a recommendation for approval or denial. So,
But it may not be questions that staff had, it may be questions that
but
one
then
of
why
us
is it?
had.
But then why is it coming to us if nobody's prepared for it? Then they shouldn't be having a recommendation for us either.
I'm not saying staff, I'm saying the applicant.
If the applicant, obviously staff has agreed with the applicant in their package or hasn't because they're bringing it to us and have already recommended denial or approval.
I understand what you're saying, but I think you're missing my intention here. When every time someone else reviews a project, you may see something that the last person didn't. And when I look at a project that comes before us, I may have questions that are different from the questions you have when you look at it.
Sure.
And if I have questions that I ask the applicant, and it's not questions that staff can answer, it's only questions that the applicant can answer. And the applicant can't answer them if it's important enough to me before I make a decision to approve the project, then I want to be comfortable in saying, I want to continue this item until the applicant can come back to me with the information I've requested. Does that make sense?
I hear you. I hear you.
Okay,
I'm not sure I totally agree, but I hear you.
okay. You don't have to agree.
I didn't say I did totally disagree.
I just think too many times we do more what I feel like we rubber stamp things a lot of times. And I don't,
And
I
using
use
that
that
term a
term
lot-
cautiously.
And using that term cautiously, a lot of what we do is rubber stamp. It's presented to us that way, and it's easy to rubber stamp it or rubber deny it. It's kind of what this board and the projects have become over the last few years. Hopefully, that's changing soon.
I just think there's times that we don't use that tool, that we have to continue a hearing until we do get all the information that we need. And that's just a tool that I wanted to remind board members that we can use when we're in that situation. How many more work sessions are we going to have on the comp plan changes, or the LDC changes?
You all are scheduled for 2 more work sessions on the Land Development Code before we start drafting the language. And then after that, you all will be reviewing the language.
One of the items that I'm interested in, I know in the last few years, council has changed some of the things that come before this board. There are some items that this board used to review that we don't any longer. Is that scheduled to come up in one of our work sessions? In the next one? And the next one is our next meeting, the end of July. Okay.
Yes, yes, and you'll be getting what's called our process table. It lists all of our applications, who's the reviewing body, who's the approval body as well. So you'll be able to see if it's blank, then that means it doesn't go to whatever reviewing body it is. And if you'd like to add the PZA as a reviewer, then you will just put the R inside that box where it's empty. But a lot of the things that you all review are the statutory applications, like your comp plan application is statutory. You don't see the annexations because the annexations are required to be considered by City Council, but not only by City Council. So you can add yourselves as a reviewer of that as well. There are applications where you can add yourself as a reviewer.
Okay, thank you. Does anyone have anything else? Mr. Wright.
Just to kind of follow up on what you were talking about, one of the things that Lonnie said tonight, that, you know, he made a point of basically saying that as we sit here, that we can listen to this person, we can listen to this person for or against, we can do certain things as long as we make a statement that we're only going to base our decision based on the evidence that we hear tonight. You know, and it goes back to what you were saying about rubber stamping. You know, that, again, and I'll refer to the first thing you talked about being the Larry rule, because I'm notorious for that, okay? You know, that, you know, a lot of times I don't necessarily contact staff, you know, because it may be something I see that, you know, I want to see the answer that night. I don't want to go and research it myself, you know, because the bottom line is then if I get the answers that I need, then I don't necessarily need to ask the question, and then nothing comes up.
Well, that's not saying that you don't ask the question anyway.
Yeah, I understand.
Because the
It
rest
just
of
seems
us
like it's
may-
making the process even easier for us just to be able just to approve things, because we've already given all the answers either, and no offense to staff, but to staff, who then can contact the applicant, and they can work it all out before they show up at the meeting and have all their answers really done, ready, and ready to go. So I understand what you're asking for, but I also understand that there's, you know, my opinion is that what we hear that night could direct the way we are one way or another, you know? So I may have questions ahead of time, and my questions actually may change while what I'm hearing, you know, and
Certainly.
I may change them at that time. So the thing you're talking about was a completely different situation. And unfortunately, staff was one that fell victim to it, but bottom line, it was somebody that was they weren't doing what they were supposed to be doing with the codes. They were sliding through, and then they were basically coming in and saying, okay, well, now fix it for me, okay? So there wasn't any way to go after them, so it was basically, necessarily make it inconvenient, that they need to go through and follow different procedures and get us more information. So it's atypical of what we would normally do. But, again, like I said, I understand your question about asking for questions ahead of time.
Well, and sometimes it's the process. If you are looking at something, you want to know, well, how are we supposed to do this? How are we supposed to do that? That sort of thing. Sometimes it's nothing but the process about how that particular item is going to work, as opposed to fact-based questions. Does that make sense?
Understood. No, and I agree with you about, we have a tendency to let the applicant, if they can't answer the questions, we have a tendency to move forward one way or another without, going and stopping the proceeding and asking to get more information. That was an instance where we did that, so.
Yeah.
So I understand. I'll do better to prepare staff. Sandbagging you.
And the other thing that is, I guess, just more of a pet peeve for me is I feel like so many times there are only a couple of us that ask questions, and it gives me the impression that no one else has read the material, when other folks don't have questions and never have questions. There was an issue with the internet today, with the packet that was on there. One of the items that was on our agenda tonight, the documentation, the backup for it was not there. There were, one item was on, the documentation for it was there twice, but the first item that was on our agenda tonight was not on the website. And when I called Patty and asked her about it today and had her send me the correct materials, and then later today I found that nobody else asked for it. So unless you picked up your book, you didn't read it. And that's what I have a pet peeve about. I guess I feel somewhat of a responsibility as chair that when I have to sit here and go through all this stuff and know what to do next, I pay a lot of attention to the book and what's in there and what we're considering, because I feel like I need to know what I'm doing. And there's nights when I get lost, when I forget whether or not we're in public hearing or we're in discussion or whatever. But I've read the material and I know something about it. There's lots of nights when I feel like maybe one or two of us do, but so the item tonight, the first one that came up, unless you had your book, you didn't read it. And I don't want to feel like I'm harping here, but if you're not interested enough to do it, then why are we here? Okay, I'm off my soapbox. Does anybody have anything else?
No, I'll take that. I didn't read it until about 4:30 this afternoon, and both were up at 4:30 this afternoon. These were both extension items. Honestly, they were rubber stamped. There was nothing. There was not a whole lot to read. You have a valid point, but not on tonight's information.
Okay. Okay, is there anything else? Seeing none, our future meeting dates are July 9th for a regular meeting, July 23rd for a work session, and August 13th for a regular meeting. Do we know that there are things for the July 9th and August 13th?
The land development code is July 23rd. Yeah, and then the first land development code amendment for the downtown Oviedo on the park, that will probably go on the 23rd as well.
So we may not have a meeting on July 9th?
No, you may not.
Okay.
I will not be here August 13th.
August 13th, okay. Patty will make a note of that.
I'll be in Memphis.
Okay, is there anything else?
Just one thing real quick.
Mr. Wright?
It goes back to our discussion that we were having. Just as a point of note, one of the things that I sometimes feel like we struggle with is the form that we make our motions in. Where, do we want to make a motion, but we want to be able to discuss it. We want to make a motion and making sure that we put the proper language in it. If we want to add something to it or delete something or make a modification to it, that would probably be a good future work session or something to maybe get a little direction, for planning future stuff like that. Talking about how we procedural stuff on the board,
Certainly, and that's one of the things I meant about the process. If when you look at something and you see things about it that perhaps you think you may want to, additional conditions that you are considering and that sort of thing, that's a good phone call to staff to say, I've reviewed this, I'm thinking about this, or this, should, for one, the 50-foot lots where I thought they ought to be 60 foot. When I looked at the material and I looked at that and thought, I don't know that those are wide enough. The best thing to do then is call staff and say, I'm considering this, I've reviewed the material. If I decide that's what I want to do tonight, how do I make that motion? What do I need to say in it? How do I list the conditions? If there's something that's come to us from DRC and maybe DRC recommended certain conditions, but you don't agree with some of them, you think you want to change it somehow, that's a good phone call to staff to say, I want to amend this, I think, tonight. Of course, you'll make the decision once you're here and you hear everything. But if you're considering that ahead of time, that's a time to call staff and ask them how to do it. Certainly having a session to talk about that process and how to do it, I think would be a good future meeting item. And maybe depending on how long the work session is on the 23rd, we could add it that night or do it another night.
We can add it that night. We'll have Lonnie here as well that night.
Because that would be my question. If you talk to staff, now do you have to present in front of the board that you did talk to staff about this issue? Just like if you talk to a resident or you talk to the applicant or whatever, or you went to the site, do you have to make it known in front of the board that you did talk to staff?
That's a good question to ask Lonnie when he's here again. Talk to him about it.
I think talking to staff is considered ex parte.
I don't know.
I don't know. But then they're getting staff.
But remember, they're our staff.
Oh, I know
for
that,
this sort of
but
thing.
Still, you have
So,
to make it note that you did talk to them.
I don't think so.
No, you don't make a note that you talk to
Oh,
staff.
okay.
It's only with ex parte communications with
Okay.
the applicant and residents.
Okay.
Okay, is there anything else? Do you have a motion to adjourn?
Second.
All those in favor say aye.
Aye.
We stand adjourned.